So, Abby, obviously there's been a big change in divorce procedure. It was a few years ago now, but I certainly still get asked about what is no fault divorce? Why is it different? What has happened?
Oh, no, me all the time. In terms of your initial meeting, as lawyers, we tend to focus on, okay, what are we going to do now? A lot of clients come into the meeting thinking about what's happened in their marriage and what has caused that breakdown of the marriage. And they want to talk about that and they want to blame their partner for what's happened if they feel like it's their fault. And we used to have conversations with them. I certainly had them a lot. I'm sure you did too, going through the different bases on which you could issue divorce before no fault got brought in. So one of them being unreasonable behaviour and listing out, 5 or 6 examples of behaviour that you consider to be unreasonable. And all of that has now been moved and put to one side and said, no, we're just going to have a divorce on the basis that the marriage has broken down irretrievably. We don't want the animosity about blaming each other and creating all of that friction. And it simplifies things so much, and certainly from our perspective. But for clients, it's still something that they do not really understand and want that bit more guidance around why can't I say what he or she has done?
Yeah, I find it difficult because some clients very much want to have it all set out. He did this, he did that, she did this, she did that, and they want that almost cathartic thing of putting it all down and having it there in the paperwork. Other clients we have, often celebrities, they don't want any information about their private life on any divorce paperwork. So they very much welcome the no fault procedure, which is much simplified and doesn't have any information like that on it. I mean, is that something you found as well?
Absolutely. And I used to say to clients in the previous system, write me your divorce petition, set out your unreasonable behavior, use that as your way of, putting it down. But that's not what I'd recommend you send into
Mm.
court. And it became a bit of a situation where you'd have some people that would try and raise the temperature and want to get it all out there and write it down. And then others, like you say, particularly with if somebody is in the public eye, they're worried that that information is going to get out somehow, then they don't want anything to be particularized as a unreasonable behavior that could come back on either of them. So you found in situations where, because you used to only be able to rely on adultery, unreasonable behavior, the fact you'd been separated for 2 years and you both agreed. If you'd been separated for 5 years, you didn't need their agreement, or they deserted you, which I think in 10 years I had one potential
Mm.
desertion. But with the unreasonable behavior one, that was the most common. And you'd have couples that were amicable and had separated. They didn't want to have to wait 2 years. They didn't want to have to blame each other. And I used to say to them, my husband could definitely do an unreasonable behavior petition on me. I could do one on him. He doesn't put the dishes in the dishwasher, doesn't take the dog out for a walk. That's something I consider unreasonable. And it wasn't about having that worst behavior you could possibly think of. So I had a client who their spouse was a really big gambler, and that had obviously caused a lot of friction in the marriage. He'd lost considerable amounts of money. He'd gained it, he'd lost it. So their fortunes, would one day there'd be a couple thousand in the bank, the next there'd be hundreds of thousands, and then it would go overnight. But my client was absolutely adamant that was not to go anywhere near the divorce
Mm.
paperwork because that had caused the breakdown and they wanted to move on. So having to craft a behaviour petition that satisfied the judges that there was unreasonable behaviour, but also then didn't mention the biggest reason for the breakdown was quite tricky. And we did have to have negotiations back and forth about the exact wording, where the comma went, and all of that just adds to the cost. So a lot of people thought when no fault gets brought in, lawyers are going to hate it because, our costs will go down. We're not going to have that argument. Whereas lawyers were the main advocates for it because we were saying, why create those arguments when you don't need to? Most cases, the divorce should be the most straightforward part of it. Let's focus on the children. Let's focus on the finances. Let's not get into an argument of, was he playing Xbox too long? Did she spend too much on a handbag that month? Let's put all that to one side. But for some clients, they want to tell you that, and that's fine. And it's good to know the context, and it's good for them to have that way of setting that out, but it doesn't necessarily need to be in the legal context.
Exactly. I mean, one of the other difficult conversations I think we have with clients around the same sort of subject is the impact of the reasons why the marriage broke down on a financial settlement, for example. I think there is a big misconception that, for example, if somebody's had an affair, the other person, the victim, so to speak, is going to receive a larger share of the finances. Do you also find that that is what people think?
Absolutely. And that is often what people bring into the first meeting and saying, well, I've got this evidence, this affair's been going on for this long. And you do have to have those conversations with them to say, I really appreciate that that has taken a big toll, that emotionally and mentally that's very difficult to deal with. And that's going to frame how our discussions might go and where you might feel in terms of offers and things like that. But from a legal point of view, and I have to put it bluntly to a lot of people, it makes no difference. They could have had one affair, they could have had 20. It's about what's actually happened in that case. What is the money that we're looking at? What's the impact of that conduct on the money? Is there one? And if there's not, the courts are very much, we're not going to touch this. What happened in the marriage, you two adults, there are going to be disagreements, there are going to be infidelities, and the judge isn't there as a moral guide. They're not there to judge who did what in the marriage from that perspective. They're there to look at, can we sort this out? Can we get the money sorted in a way that's fair? And sometimes the party that feels aggrieved might not consider that that is fair. And it's our job then to explain why, what it looks like, and help them see a future that gives them stability and gives them what they want, whilst acknowledging that it may not, in their mind, completely pay back what's happened to them.
I think that's the key point of the way we work with our clients. It's very much forward looking, isn't it? Getting them into a position where they can rebuild their lives and be in a secure position moving forward.
No, absolutely. And that's, when I speak to clients, I want to make sure they've got a team around them. So that's, the team with us, making sure that, we get on and we say to the clients, look, you've got to be able to ring me up and have a chat with me and tell me anything that you're concerned about, and then take on board my advice, trust my advice. But have that other team around you, have the support there. Friends and family are brilliant, but, are there other professional support that we need to have in your corner, so that you are making these decisions which have long-term implications. You're deciding your financial future. You only get one chance to do this in a divorce. So let's make sure that you can make all those decisions from the right place, and that you're then comfortable accepting those decisions and moving forward.
That's really interesting insights. Thank you, Abby.